And again, for the application of standing orders, we all know that currently, if the industrial employment standing orders has to apply to a particular establishment, that establishment should have 100 or more workers. That threshold limit is also getting increased from 100 to 300, right? And if the standing order differ from the model standing orders made by the central government, right? Otherwise, they can adopt the model standing orders itself. That possibility is there. And it provides that if the employer prepares and adopts model standing order of the central government with respect to the matters relevant to the employer's industrial establishment, then the model standing order would be deemed to be certified. Right. Again, even if a separate set of standing orders are not drafted by the establishment concerned, instead they would like to adopt the model standing orders, they can do so. But again, they may have to draft it, submit it for the approval, so that they can adopt the model standing orders in their establishment, as that will become automatically law for that for their establishment. And another concept is introduction of reskilling fund, right? For those retrenched workers, this particular fund is created. So normally 15 days of wages for every completed year of service, that will be paid as compensation to the people who are retrenched from services, right? In addition, 15 days wages alone is to be paid by the employer to this fund, right? The idea is to retrain these retrenched workers so that their services can be utilized elsewhere, so that they become employable. Yeah, and provisions are being made to have two. I think Justice Vaidyanathan touched on this. Have two members, two-member industrial tribunals, with second member being from administrative side in place of single-member labor court and industrial tribunal at present. Right. I think the number of machineries available is also coming down. Right now we have conciliation officers, board of conciliation, court of inquiry, labor court, industrial tribunal, national tribunal. Right. Instead, I think the court of inquiry, labor court, those are all board of conciliation, all going off, right? So conciliation officer will be there and the tribunals will be there, industrial tribunal and national tribunal. That is what is planned, but let us see how it works out. Further, the tribunal will be empowered to execute the award as a decree of a civil court, which will facilitate speedy disposal of disputes. Okay. To provide for continuation of services of providing, I think, the presiding officers of the existing adjudicating authority. This also, I think, Justice Vaidyanathan touched on this. To provide that reference by the government will not be required for industrial tribunal, except in case of national industrial tribunal, right? Now, I think to prohibit strikes and lockouts in any industrial establishment without giving notice of 14 days. I think currently also the same position. So notice is to be given only after a lapse of 14 days, they can go on strike. Currently, the same provision is there. And during the conciliation proceeding, it is not possible. They cannot go on proceed with the strike. And to provide penalties for different types of violations to rationalize with such offences and commensurate with gravity of the violations. Again, here also penalty, the quantum is going up. And one additional thing here is to empower the appropriate government to appoint officers for holding inquiry and impose penalty in certain contraventions punishable with fine up to rupees 15,000. If it is up to rupees 15,000, I think central government can empower appoint officers. They can maybe impose penalty, and maybe the employer can be let off with that. And compounding of offense, it is possible, but here there's a slight change, because in other courts, those punishments for which imprisonment is also prescribed. I think for that maybe commitment of such action, the compounding of offense is not possible, right? But here, even if the punishment of imprisonment is prescribed, if it does not go beyond 1 year, that is possible. So there is a fine, and imprisonment is also prescribed. But if the imprisonment period does not go beyond 1 year, I think the compounding of offense is possible only under IR code. Now, so this is how the chapters are arranged as far as the industrial relations code are concerned. Again, chapter 3, trade unions. So hitherto it is a separate legislation, Trade Unions Act. Similarly, standing orders, chapter 4. Right, it is the Industrial Employment Standing Orders Act, again in 1946. Hitherto, I think it is a separate legislation. Now it is getting subsumed into industrial relations. Other parts, I think it is almost similar to Industrial Disputes Act. Now it is called as industrial relations. Now, I think some of the significant points or changes. The definition of the term industry is modified in line with the Apex Court verdict in Bangalore Water Supply and Sewerage Board case. We discussed on that. And the domestic services and the institutions engaged in charitable, social, or philanthropic services are clearly excluded. They are not treated as industries. And termination of the service of a worker on the grounds of continued ill health is not considered as retrenchment, which means this falls under exception to retrenchment. This is not considered as retrenchment. Then concerted mass casual leave, we discussed, that could be considered as a strike now. And the maximum number of members of the grievance redressal committee, it is increased from 6 to 10, right? I think this is under section 9 capital C currently, but that number is prescribed as maximum 6, right? That is now increased to 10 under the code. And of course, equal representation from the workers and also representative of women employees, if they have women workers, that should be there. And notice shall not be required for effecting change in case of emergent situation. So requiring change of shift or shift working, otherwise almost similar to maybe section 5 of the current Factories Act, I would say. So what is the emergent situation? All those things, yes, details we may have to wait and see. And it prohibits strikes and lockouts in any industrial establishment without giving notice of 14. So minimum 14 days notice is required and maximum 60 days is required. Maximum is currently now 6 weeks. So 6 weeks is going up to 60 days, right? Then willful go slow, that will be considered as unfair labor practice on the part of the worker concerned, right? So punishment can be, maybe action can be taken based on that. And the time period for filing a grievance application, it is reduced from 3 years to 1 year, right?